The Senate Judiciary Committee approved a ban on assault weapons and high-capacity ammunition clips. The proposal, authored by California Senator Dianne Feinstein, bans 157 different models of assault weapons and magazines containing more than 10 bullets. The measure, which passed along a party-line vote, now goes to the full Senate.
On the way here, Senator Cornyn, Senator Grassley, and I, Senator Feinstein, Senator Durbin, here, and others, and I know others are on their way. We're going to have appropriations bill on the floor, and I'm advised votes this morning. So I hope we can get moving quickly. Last week we had a bipartisan vote for the Stop Illegal Trafficking in Firearms Act. We had another bipartisan vote for the School Safety Enactment Act. We reported the Protect and Responsible Gun Sellers Act, so we've done 3 of the 4. We've acted on legislative proposals to make gun trafficking and straw purchasing crimes, enhance the safety of our children's schools, and close loopholes in the background check system. Excuse me. We'll complete action. Senator Feinstein's proposal reinstitutes an assault weapons ban, place limitations on high-capacity ammunition magazines. I think everybody's given as many statements as they want to give, and so I'll yield to Senator Grassley if he has any, and then we'll go right to the we have the senior senator from California, the senior senator from Texas, and I know the senator from Texas has amendments, and as soon as we have 8, we'll go to that.
Yeah.
Go ahead, please.
And I won't speak anymore on the legislation that's before us unless Senator Feinstein forgot what I've said.
She hasn't.
I haven't.
Oh, you haven't.
None of us have.
Indelibly impressed.
Okay, thank you. And I think as long as I have the floor, I'll say what we normally say about what's on the agenda. We have the 2 nominees on the agenda. We have a request on our side to hold them over, so I won't have to repeat that when you take that business up. In regard to the rest of the markup, just one sentence. Well, maybe I'll say a procedural thing, because I know we have amendments on our side, and even though I don't have anything to say on the bill further, I hope we respect everybody's right to offer amendments. Whoever on our side wants to do that, even beyond Senator Cornyn. The only thing that I want to say is I'm still amazed that after we've had 2 witnesses in 2 hearings from the Justice Department, we still have not received an analysis from the department on the constitutionality of the legislation that we're going to be seeking today. That's all I have to say.
Okay, we have now Senator Schumer has joined us. Yes, Senator Reynolds, Senator Franken, Senator Durbin, Senator Schumer, Feinstein, myself, Senator Grassley, and Senator Cornyn. We have enough people that Senator Grassley's request, Jane Kelly of Iowa, the U.S. Circuit Judge for the 8th Circuit, be held over. We've held over Ken Gonzalez before, but Senator Grassley has asked me again postpone it until allegations made in a recent defense motion of pattern and due to a Brady violation of the Mexico U.S. Attorney's Office can be looked into further. I reviewed the matter. I'm prepared to move forward, but as a courtesy, of course, to the ranking member,
Yeah.
we'll hold over another week.
Yeah, I'd like to add to what you just said that I've had discussions with both of the senators from New Mexico, and I feel that they understand what we're trying to get answers to, and they, I think I've satisfied them for a while, and I don't think it's going to take very long. But
no, you've not made any attempt to hold this up for the sake of holding up. I know you have talked with the senators, and I appreciate that. They both told me that you did, and I think in the following the normal comity in this committee, I'm happy to hold over again. So, Senator Cornyn, you had an amendment?
Can I ask,
Oh.
Senator Leahy has a statement that I'd like to put in the record.
And the record will be open for any statements, and Senator Lee's statement, of course, will be made part of the record. Senator Cornyn?
Thank you, Mr. Chairman. I know Senator Feinstein has fought for this legislation and is passionate about her belief in the need for this legislation, and I respect her conviction, although I must strongly oppose the bill. As I said last week, gun violence is a tragic problem in the United States, and it's our responsibility to address the problem on behalf of the American people. And we could do that right now with broad bipartisan support if we're willing to address the serious deficiencies in our mental health system, improve the background check database, and do a better job, the executive branch, of enforcing existing law. I'm encouraged, as I said, that some like Senator Graham, and I know there are others on the committee who support legislation suggesting methods to patch the holes in the background check system. I'm hopeful that the legislation Senator Schumer introduced and was voted out of committee, which I couldn't support in its present form, but hope we can continue to work on that and to improve it from my perspective. But we simply need to patch the holes in the background check system that enable the mentally ill to buy guns. That's the type of legislation I think would have the greatest positive impact on gun violence in America. But instead, we're considering a piece of legislation that jeopardizes the self-defense rights of law-abiding citizens while doing nothing to address the real problems. In other words, our real concern should be that efforts to enact this ineffective gun ban are distracting Congress from solutions to stop the seriously mentally deranged from buying guns. So I cannot support it. At last week's markup, I highlighted some of the serious concerns I have with Senator Feinstein's legislation. These measures were tried before 1994 and were found to be ineffectual. The bill focuses on cosmetic features of certain firearms rather than the perilous intersection of mental illness and guns. The bill does nothing to deal with the lack of effective enforcement of current gun laws. We talked about the fact that people who actually lie on background checks, there's almost a zero chance of getting prosecuted by this Department of Justice. And I believe that the bill would infringe upon the ability of law-abiding citizens to defend themselves and their families. So I do have, well, let me just add,
you have an amendment that you'd like?
I do, and I will get to it shortly. But far from banning only what the bill defines as assault weapons, this legislation would effectively ban a majority of handguns in the United States by prohibiting the use of ammunition clips that they are designed to use. We should think long and hard before going down this road. Last week's markup also made clear that the knowing and intentional effect of this legislation would prevent military veterans from choosing how best to defend their families and their communities. And in order to demonstrate what I believe to be the weaknesses and indeed, you might say, absurdities of this legislation, I offered an amendment that would have exempted these military veterans from this ban on self-defense weapons, and it was rejected by the committee. But nine of our members on the other side chose to block that amendment, and I think that was a mistake. But this will be revisited on the floor. But what I would like to do, Mr. Chairman, is to call up my amendment 13117 and ask for its immediate consideration.
This is the one to allow victims of domestic sexual violence possession.
That's correct. If I may.
I must admit, I looked at these issues a lot. I know that I've worked with law enforcement officers and others a couple of years and passed the Violence Against Women Reauthorization Act. I know that senators from Texas did not join us in that act. It's going to be helpful to victims as you wish.
Of course, the chairman knows the reason I didn't vote for that version of the Violence Against Women Act is because it contained an unconstitutional provision regarding tribal courts. Although I was proud to support many elements of that bill, I could not support an unconstitutional provision. But this amendment would allow victims of sexual assault, domestic violence, dating violence, and stalking under the Violence Against Women Act to obtain and possess the self-defense weapons prohibited by this legislation. I'd ask unanimous consent to enter into the record a letter of support I've received for this amendment from the Congressional Victims' Rights Caucus.
Without objection, it'll be introduced. Senator Feinstein, did you wish to speak on the amendment?
It's also, I'm not through yet.
I'm sorry, I thought you were.
It's also supported by the Concerned Women for America and the Eagle Forum, among others. As we all know, the Violence Against Women's Act victims are often the target of repeat offenders and a devastating cycle of violence. Several weeks ago, Gail Trotter of the Independent Women's Forum explained to the committee that guns are a great equalizer for women trying to protect themselves from aggressors. In particular, she noted that AR-15s, which are prohibited by this legislation, are the weapon of choice for many women due to their accuracy, easy handling, and light weight. But it's also important to note once again that this legislation would effectively ban millions of handguns by outlawing the ammunition magazines they're designed to accept. The handgun is by far the most common and effective self-defense weapon used by women in the United States. And so this legislation would have a disparate and tragic impact on female crime victims. And for those reasons, I would urge the amendment's consideration and passage.
Thank you very much. Senator Feinstein.
Thank you very much, Mr. Chairman. Very briefly, I oppose this amendment. I hope we will vote no on it. We have looked for instances of self-defense. We have not found any. We have asked individuals. No one has presented me with any evidence that a person fares better in self-defense with an assault weapon or a large capacity magazine than with a standard handgun. If the senator has any evidence, I hope he would present it. That's evidence where an assault weapon has actually been used for self-defense by people who have been victims of sexual assault, domestic violence, dating violence, or stalking. The law enforcement witnesses at our last hearing all testified that no one needs an assault weapon or large capacity magazine for self-defense. Chief Flynn of Milwaukee testified, and I quote, "The notion that innocent law-abiding citizens will use an assault weapon or high-capacity magazine to protect themselves is generally disproved," end quote. Mayor Nutter of Philadelphia testified that, quote, "This idea that these weapons are for self-defense is based on our experience completely absurd. They are self-defense weapons." U.S. Attorney for Colorado, John Walsh, testified, and I quote, "A 10-round magazine is sufficient to subdue a criminal or potential assailant." There's been a lot of research done that discounts the idea that these weapons are effective self-defense weapons, so I urge a no vote.
If I may respond briefly. As I said, I respect the distinguished senator from California, but I would refer her again to the testimony of Gail Trotter, who testified before the committee that these guns are a great equalizer, including the use of an AR-15, which would be prohibited by this act. That's testimony before the committee that should be considered. And I might note the Vice President has also apparently believes that a handgun is insufficient for self-defense because he's advocated use of a shotgun on at least one of occasions. I would also ask Mr. Chairman to make part of the record a listing of 9 separate incidents of people defending themselves with assault weapons that would be prohibited by this legislation.
Let me include in the record. No further discussion.
Call the roll.
Senator from Illinois.
Just very quickly, then I would also like to include in the record this morning's Chicago Tribune story where the police officers in the city of Chicago in East Garfield Park shot to death a 58-year-old man who refused to drop an automatic assault weapon. which he pulled on the policeman. Certainly not a weapon which police often carry, but now face from criminals on the street with regularity.
Mr. Chairman, and just concluding, I would say that the underlying bill exempts retired police officers. And the rationale for that, which I support, is that they can use their weapons. They're trained in these weapons. They can use them for self-defense. So why we would deny other American citizens the right to legitimately use these weapons for self-defense is, it escapes me.
I think there's a larger issue here that we ought to think about. And what Senator Cornyn is trying to do is protect constitutional rights. And I think everybody's trying to put the burden on Senator Cornyn to do that. The burden ought to be on those people that are trying to limit constitutional rights. I'm done.
Clerk, call the roll.
Mrs. Feinstein.
No.
Mr. Schumer.
No by proxy.
Mr. Durbin. Mr. Whitehouse.
No by proxy.
Ms. Klobuchar.
No by proxy.
Mr. Franken. No. Mr. Cruz.
No by proxy.
Mr. Blumenthal.
No.
Ms. Hirono. Mr. Grassley.
Aye.
Mr. Hatch.
Aye by proxy.
Mr. Sessions.
Aye by proxy.
Mr. Graham.
Aye by proxy.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye by proxy.
Mr. Cruz. Aye. Mr. Flake.
Aye by proxy.
Mr. Chairman.
No.
Mr. Chairman, the votes are 8 yeas, 10 nays.
Senator Schumer. Senator Schumer be recorded no in person.
I have another.
Senator Cornyn, you have the floor.
Mr. Chairman, I would call up Amendment 13116 and ask for its immediate consideration.
No objection is before the committee.
This amendment would allow persons who have obtained a protection order, which is actually a broader definition than just merely a protective order as ordinarily thought of. This would allow people who have obtained a protection order as defined by the Violence Against Women Act to obtain and possess the personal self-defense weapons prohibited by this legislation. The National Coalition Against Domestic Violence estimates that 1.3 million a year women are traumatized by domestic violence, and that 1 in every 4 women will experience domestic violence in her lifetime. When sexual assault statistics are added to this estimate, the numbers are staggering. To the most vulnerable of these women, the protection order is a living symbol of their struggle and a certification of the real threat of danger they and their families must live with every day. And we should ensure that at the very least, these law-abiding Americans are able to own and possess the very tools necessary to protect themselves from becoming a tragic statistic. So I'd ask my colleagues to support this amendment, which would allow individuals who have obtained a protection order as defined by the Violence of Women Act to obtain and possess these self-defense weapons prohibited by this legislation.
Thank you very much. Senator Feinstein.
I would urge a no vote. Again, in my view, there is no strong evidence that these weapons are used for self-defense, nor do I believe you need clips, drums, or ammunition feeding devices of more than 10 bullets for self-defense. What Senator Biden said is if you really want a weapon, use a 12-gauge shotgun. Shotgun is not an assault weapon. I think we demonstrated where these assault weapons can have different slides put in them, which essentially make them act like fully automatic weapons. These weapons are generally able to be spray-fired. What's happening here, and I think we'll see more of these amendments, is an effort to nip it and tuck it and create exception after exception. I really resist this effort. I urge a no vote.
Clerk will call the roll.
Mrs. Feinstein.
No.
Mr. Schumer. No. Mr. Durbin. No. Mr. Whitehouse.
No by proxy.
Ms. Klobuchar.
No by proxy.
Mr. Franken. No. Mr. Cruz.
No by proxy.
Mr. Blumenthal. No. Ms. Hirono. No. Mr. Grassley.
Aye.
Mr. Hatch.
Aye by proxy.
Mr. Sessions.
Aye by proxy.
Mr. Graham.
Aye by proxy.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye by proxy.
Mr. Cruz.
Aye.
Mr. Flake.
Aye by proxy.
Mr. Chairman.
No.
Mr. Chairman, the votes are 8 yeas, 10 nays.
The amendment fails. You know, not necessarily because of this last amendment, but I was thinking of some of the discussions of what kind of firepower people need in their homes. And one of the discussions sounded almost like somebody had been to one of these movies of the zombie takeovers when you need all kinds of firepower as they march at it. I've always been perfectly satisfied with my 45 I have at home. Well, others too, but even when we had people escaping from prison announcing they were going to kill me, I felt pretty comfortable with that. I didn't feel it necessary to shoot up my neighborhood with a semi-automatic assault weapon, but I guess everybody depends upon how good a shot they are. Senator Cornyn, go ahead, please.
Well, Mr. Chairman, we certainly won't ask you to inventory your arsenal that you maintain at your home in Vermont.
We would lose a quorum by the time it takes to call the whole inventory, Senator Cornyn.
Before Senator Cornyn speaks, in response to what you said, it seems to me you're raising the question about the firepower that a person ought to have maybe to protect their home. Isn't the rule ought to be that you would have the firepower commensurate with possible aggressors, what they might have?
If you have a zombie assault, that's a different thing. But go ahead, please, Senator Cornyn.
If I may just ask, before going to my next amendment, just ask the senator from California, what's the purpose of the exception for retired police officers in the bill?
Well, the reason for retired police officers is that generally they do maintain their weapon, they do keep their weapon. The retired police felt strongly, and this is a problem for them if you're going to remove weapons for them. And in the crafting of the bill, we obviously made certain compromises and made certain changes, and that was one that we made.
Mr. Chairman, I'd call up my amendment 13118.
13118, and without objection, that's before the committee. Senator Cornyn, you have the floor.
Mr. Chairman, this amendment would allow residents of counties that are on the southwestern border to obtain and possess self-defense weapons prohibited by this legislation. As we know, just across our border to the south, transnational criminal organizations are equipped with fully automatic military-style weapons and trained in military tactics, and they're committing hundreds of thousands of acts of violence every year. These organizations have also expanded their footprint to the United States through drug trafficking and human trafficking. These cartels are dangerous, as are the gangs that support their operations, and we know that they are operating along the southwestern border. I cannot in good conscience tell my constituents that the federal government is going to deny them the freedom to defend their families from these transnational criminal organizations, and I'd ask my colleagues to support the amendment.
If I may respond, thank you. Again, this is another way to create a nip and a tuck. I would like to point out to the body that the bill contains nearly 100 pages of weapons by make and model that are exempted. There are plenty of weapons out there. The whole point of this bill is to reduce over time the supply, the possession, the transfer, and the sale of military-style weapons. And anyone that has a concern that their weapon is affected need only look at the bill, and you'll see most likely your weapon is exempted by name, make, and model. And that is from everything from handguns to centerfire rifles and on and on. So I'd like to make that point. I'd urge a no vote.
Could I speak, please?
Certainly.
I think this brings up a bigger issue. I support the amendment, but I think we ought to remind everybody that when it comes to the citizens of any place in the United States, either local government is going to support them or protect them, or the federal government. In the case of immigration, it's quite clear that that's the responsibility of the federal government to protect our borders, secure our borders, and protect our sovereignty. Now, in the southwest of the United States, we got people being murdered by the very example that, or the reason for his amendment. The federal government's not doing their job, or these folks wouldn't get across the border. So Arizona steps in, some legislation, saying, well, the federal government's not protecting our people. Under the 10th Amendment, the state's rights or state responsibility of protecting the safety and welfare of their citizens step in to do it. And you know what? The federal government starts suing the state of Arizona. If the federal government was doing its job, Arizona wouldn't have to step in, wouldn't have to spend all this money. So Senator Cornyn comes up with his amendment. If the federal government isn't going to do it, are we going to allow the individual citizens to do it? If the governments don't do it, the Second Amendment is the right of self-protection. And we ought to respect that right, and we ought to give the people the power to do it if they want to protect themselves when the state government isn't doing it, and the state government wouldn't have to do it if the federal government was doing its job. And then instead of suing the state of Arizona, the President of the United States ought to be stepping in there and saying, we'll work with you to protect your citizens.
Mr. Chairman.
Senator Blumenthal.
If I may respond not so much to that point, but to the general line of argument that I think is raised by these amendments, which is a self-defense argument. And I respect Senator Cornyn's desire to provide defense or the means for self-defense to victims of domestic violence and to victims of assault, and I think we all do. The question is, what kind of weapons are necessary or best suited for that defense? And obviously, the Second Amendment guarantees every individual, regardless of whether he or she is a victim of any crime, sexual assault or otherwise, to self-defense. The Heller decision makes that point clear. I think the question really is, what kind of weapon provides the best or safest means of defense? And I think the testimony before this committee was very clear that the use of these assault weapons is primarily for criminal purposes. It's an offensive weapon. It's a military-style weapon that was designed and made for our military to kill people, and it may be used to kill people for self-defense, but the experience is that self-defense is best done by other kinds of weapons which are commonly used at close range. And as one of the witnesses, U.S. Attorney John Walsh, said, the majority of shootings in self-defense occur at close range. A 10-round magazine is sufficient to subdue a criminal or potential assailant. Chief Flynn said much the same thing, that that these assault weapons are commonly used by criminals, often against police, not by people in self-defense. So I think it is the nature of the weapon that is at issue here, and assault weapons, because they are so extraordinarily damaging, they cause multiple wounds, more serious wounds, often with police officers as their victim, are simply appropriate to be banned with the very well-defined and explicit approach that this proposal takes. And so I think these amendments, while they may be well-intentioned, and I agree with their purpose in providing means of self-defense to victims of these horrendous crimes, can be done better by other types of weapons.
I would just respond to my friend and say, why would we want to make an otherwise law-abiding citizen into a criminal if they want to use these weapons to defend themselves and their families? I see that as the effect of this legislation. I also believe that if the criminals that you allude to, and as a former Attorney General, you know this area as well as anybody, if the criminals element is going to be using weapons like this, why would you deny for defensive purposes otherwise law-abiding citizens to be able to use an equivalent firepower to defend themselves. It's not much satisfaction to say that criminals are going to have access to the whole range of weapons that they will have access to because they don't care about the laws that are passed. And we're going to give the American citizen a pea shooter to defend themselves with. I just think it's inadequate, and you are criminalizing otherwise law-abiding citizens inappropriately, in my view.
Mr. Chairman.
Senator Cruz.
If I might pose a question to the senior senator from California. In your response to Senator Cornyn, you mentioned that there's some 100 pages of the bill that specify particular firearms that if this bill were passed, Congress would have deemed prohibited. It seems to me that all of us should begin as our foundational document with the Constitution. Mm-hmm. And the Second Amendment in the Bill of Rights provides that the right of the people to keep and bear arms shall not be infringed. The term, the right of the people, when the framers included it in the Bill of Rights, they used it as a term of art. That same phrase, the right of the people, is found in the First Amendment, the right of the people to peaceably assemble and to petition their government for redress of grievances. It's also found in the Fourth Amendment, the right of the people to be free from unreasonable searches and seizures. And the question that I would pose to the senior senator from California is, would she deem it consistent with the Bill of Rights for Congress to engage in the same endeavor that we are contemplating doing with the Second Amendment in the context of the First or Fourth Amendment? Namely, would she consider it constitutional for Congress to specify that the First Amendment shall apply only to the following books and shall not apply to the books that Congress has deemed outside the protection of the Bill of Rights? Likewise, would she think that the Fourth Amendment's protection against searches and seizures could properly apply only to the following specified individuals and not to the individuals that Congress has deemed outside the protection of the Bill of Rights?
Would the Senator yield for a question?
Let me just make a couple of points in response. One, I'm not a sixth grader. Senator, I've been on this committee for 20 years. I was a mayor for 9 years. I walked in, I saw people shot. I've looked at bodies that have been shot with these weapons. I've seen the bullets that implode. In Sandy Hook, youngsters were dismembered. Look, there are other weapons. I've been I'm not a lawyer, but after 20 years, I've been up close and personal to the Constitution. I have great respect for it. This doesn't mean that weapons of war, and the Heller decision clearly points out 3 exceptions, 2 of which are pertinent here. And so you know, I mean, it's fine you want to lecture me on the Constitution. I appreciate it. Just know I've been here for a long time. I've passed on a number of bills. I've studied the Constitution myself. I am reasonably well educated, and I thank you for the lecture. Incidentally, this does not prohibit, you use the word prohibit, it exempts 2,271 weapons. Isn't that enough for the people in the United States?
Mr. Chairman?
Do they need a bazooka? Do they need other high-powered weapons that military people use to kill in close combat? I don't think so. So I come from a different place than you do. I respect your views. I ask you to respect my views.
Mr. Chairman.
Senator Durbin, it's not.
Mr. Chairman, I can't add anything to that.
Okay. Senator Cruz.
Mr. Chairman, I would ask yet another question of the senior senator of California. I think nobody doubts her sincerity or her passion. And yet at the same time, I would note that she chose not to answer the question that I asked, which is, in her judgment, would it be consistent with the Constitution for Congress to specify which books are permitted and which books are not, and to use the specific number?
The answer is obvious, no.
And if I may ask...
Could we keep on the, and I appreciate we have a discussion on books. I know that they have that in your state of Texas where your educational boards tell people what books they should or should not read in their schools, something that we would not do in Vermont, but you know, we're not going to talk about your right. Well, yeah. But let's stick to guns. And I know Senator
Mr. Chairman, I appreciate your acknowledging that the state of Texas allows books. I would specify a little more broadly.
Child pornography books? Child pornography?
Protected by the First Amendment?
It's obvious that there are different tests on different amendments. And I think what the senator is going to point out was something that didn't occur to me at the moment. There are certain kinds of pornographic materials that would not be covered by the First Amendment.
And is it the view of the senior senator from California that Congress should be in the business of specifying particular books, or for that matter, with respect to the Fourth Amendment, particular individuals who are not covered by the Bill of Rights?
Sir, Congress is in the business of making law. The Supreme Court interprets the law. They strike down the law, they strike down the law. The tests in Heller, with respect to unusual weapons and two other things, I think do not cover, in other words, they cover an exemption for assault weapons. And if this is brought up before the court, if it should pass, I'm sure that argument will be made.
Senator from Illinois,
That's exactly the point. The senator knows, having attended law school and professes to have some experience in the Constitution, none of these rights are absolute, none of them. And the Heller decision goes specifically to the question of this amendment and tells us, when they were asked in the Heller decision, a panel, Heller 2, a panel of Republican-appointed judges rejected a Second Amendment challenge to D.C.'s assault weapons ban and magazine limits. A Second Amendment challenge. The D.C. Circuit Court held that such laws, quote, do not effectively disarm individuals or substantially affect their ability to defend themselves. I could go on, but I think the senator from California has made this case.
the clerk will call the roll.
Mrs. Feinstein.
No.
Mr. Schumer.
No.
Mr. Durbin. Mr. Whitehouse.
No by proxy.
Ms. Klobuchar.
No.
Mr. Franklin.
No.
Mr. Cruz.
No by proxy.
Mr. Blumenthal.
No.
Ms. Hirono. No. Mr. Grassley. Mr. Hatch.
Aye, by proxy.
Mr. Sessions.
Aye, by proxy.
Mr. Graham.
Aye, by proxy.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye, by proxy.
Mr. Cruz.
Aye.
Mr. Flake.
Aye, by proxy.
Mr. Chairman.
No, no, for the record, Senator Graham is here.
Mr. Chairman, the votes are 8 yeas.
As much as
10
I'm over
nays.
here, I'm here.
Oh, okay.
Mr. Chairman, I have
The amendment fails. Are there further amendments?
one other amendment
Please.
for present
go ahead.
present purposes. Again, as
Incidentally, I appreciate and I mean this sincerely, I appreciate the courtesy of the senior senator from Texas who has told us well in advance which amendments he's going to have, and he has not taken an undue amount of time, and that means a lot to me. So please go ahead.
Again, the fundamental flaw, I think, in the legislation is assuming that certain types of weapons will be used only for offensive purposes. That's wrong. If it were true, the bill itself would not exempt retired law enforcement officers from the criminalization of the possession of these weapons. And so, to further point out that that fundamental flaw in the legislation, I would call up my amendment 13181. This is
131.
and ask for its immediate consideration. Mr. Chairman, this amendment...
The amendment, the senator has that right, and the amendment is before the committee.
Mr. Chairman, as the distinguished ranking member pointed out, not all of America is urban. There are large sections of rural America where government, including law enforcement officers, are not omnipresent. This amendment would prevent the bill from threatening the safety of law-abiding citizens living in rural areas and rural communities of our country by exempting them from possession of these self-defense weapons. The Violence Against Women Act itself recognizes that citizens in rural areas and communities deserve special protection under our laws. In my home state of Texas and around the nation, rural Americans often live far away from the protection of law enforcement officials. And this committee should recognize the vast differences between different regions of our country before enacting blanket bans on personal self-defense weapons from Washington, D.C. We must ensure that rural Americans are able to fully protect their families before the police arrive too late at the scene of a violent crime. And my amendment exempting otherwise law-abiding citizens living in rural areas from the criminalization attempted by this legislation by exempting them from prohibitions on the possession of these weapons for self-defense purposes. And I ask my colleagues to support it.
I thank the distinguished senator. Is there any comments?
Urge a no vote, Mr. Chairman.
Senator Feinstein has urged a no vote. I pay particular attention to this, living on a dirt road in a town that has no police force.
Well, Mr. Chairman, it sounds like with the guns you have, they don't need a police force.
I feel adequately protected. The clerk, call the roll.
No.
Mr. Schumer.
No.
Mr. Durbin. No. Mr. Whitehouse.
No by proxy.
Ms. Coulter. No. Mr. Franken. Mr. Coons.
No by proxy.
Mr. Blumenthal.
No.
Ms. Corona. No. Mr. Grassley. Mr. Hatch.
Aye by proxy.
Mr. Sessions.
Aye by proxy.
Mr. Graham.
Aye by proxy.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye by proxy.
Mr. Cruz.
Aye.
Mr. Flake.
Aye.
Mr. Chairman.
No.
Mr. Chairman, the votes are 8 yeas, 10 nays.
Thank you. Are there
Chairman, I would note that I do have other amendments, but in order to maintain the pleasant and disposition of the chairman and not to burn any bridges unnecessarily.
and this close to St. Patrick's Day.
I would, at least not right now, I'll withhold further amendments for the floor. Thank you.
Well, I appreciate that. The senator from Texas knows of my disappointment in not being elected Pope, so that I appreciate his courtesy there. And I know I'm going to pay for that smart aleck remark, but I appreciate the courtesy of all the senators. We've had 4
Cardinals.
I guess we're still considered Cardinals, but I appreciate the courtesy of all the senators in both parties in moving through 4 major pieces of legislation. I want to call the roll on Senator Feinstein, and I've told her I have some concerns about some aspects of it, but I feel this is a matter of such importance, it should be voted on by the whole Senate, not just by this committee, and so I will vote to support her bill as I will vote to support her bill as it is before us, and the clerk will call the roll.
Mrs. Feinstein.
Aye.
Mr. Schumer.
Aye.
Mr. Durbin. Aye. Mr. Whitehouse.
Aye by proxy.
Ms. Coulter. Aye. Mr. Franken.
Aye.
Mr. Coons.
Aye by proxy.
Mr. Blumenthal.
Aye.
Ms. Corona. Aye. Mr. Grassley.
No.
Mr. Hatch.
No by proxy.
Mr. Sessions.
No by proxy.
Mr. Graham.
No by proxy.
Mr. Cornyn.
No.
Mr. Lee.
No by proxy.
Mr. Cruz.
No.
Mr. Flake.
No.
Mr. Chairman.
Aye.
Mr. Chairman, the votes are 10 yeas, 8 nays.
And the bill will be reported to the floor. I know several senators have asked for time to speak, and Senator Feinstein, I note that we've completed the work on the agenda, but several senators have asked to speak, and I will stay here and give everybody a chance to.
We'll go back to the budget committee.
Mr. Chairman?
Senator from Senior Senator from California.
Other members want to speak on this. I just want to make a very few comments. I think every member of this committee needs to ask themselves a few questions. First, I want to thank the members that have stood with me. It is very much appreciated. As I've said before, the road is uphill. I fully understand it. I think a lot of my passion comes from just what I have seen on the streets of cities in this country. But I really think that every member of this committee needs to ask himself a few following questions. Are we going to stand with the thousands of police chiefs and law enforcement officers who do support this bill? Are we going to stand with the victims of gun violence? Are we going to stand with the overwhelming number of people? There has not been one poll done that doesn't show that a majority of Americans want this bill passed. How is this country going to be a weaker country because we don't produce millions of assault weapons to end up in the hands of gangs, to go for grievance killers. You know, let me say something about the young man at Sandy Hook, because in a sense it's typical. This is a young man who was disturbed. He was maladjusted. His mother, a gun collector, gave him this weapon, took him to the range, taught him how to fire the weapon. The first person he killed was his mother, and then he went to Sandy Hook and killed brave adults and those children. And, you know, when we hear the testimony from the emergency physician about what those bullets did inside the body of those children, it is a very sobering picture. I mean, I cannot get out of my mind trying to find a pulse in someone and putting fingers in a bullet hole. I cannot get out of my mind walking into a crime and seeing the brain matter all over, the carnage, and seeing these mass attacks continue to happen. I mean, I thought it would end with the Texas bell tower, but it hasn't. Universities, schools, movie theaters, law offices, places of employment, and these weapons become the weapon of choice. Why allow them to continue? This bill doesn't take a weapon from anybody. It simply talks about the future. It simply says if you possess one, you have to keep it safely, a trigger lock, that if you sell it to anyone but a family member, they have to have a background check. It affects clips and ammunition feeding devices. So people that want to go into a theater and kill 100 people can't do it with a 100-round magazine. I don't see that as being bad. I don't see that as harming America because we have so many guns. No nation has more guns in their civilian society than we do. And you can compare murder rates where this isn't allowed to happen. You can compare it with the UK, you can compare it with Australia, and you will see a few double digits, and then you will see thousands in America. So how is this a bad thing to do? You know, I've been in this political career, true in a city, a tumultuous city, a diverse city. I've seen, you know, a bright young police officer, a young Latino officer that everyone thought had a brilliant future in the San Francisco Police Department, walking down 3rd Street when a gang member walked the other way with an AK-47, opened his coat, and shot him dead. How many times does this have to happen? And it happens all over. That's why the police are for this. You know, you can exempt retired police. They have been trained. They know how to use these. Very different from a grievance killer. Very different from Jonesboro or Columbine or Virginia Tech. Very different. And the clips, the size of the clips, who needs it? I mean, would anyone respect someone with a 30-round clip going out and shooting deer? I don't think so. So the problem is, you know, I understand the right of people to want to collect these, and nothing takes any weapon away from anybody. And to prove it, we exempt so many weapons. So I have a hard time understanding why our country isn't better off. With respect to a case, I know others will argue this, but no assault weapons legislation has been struck down. My last bill went through the 4th, the 6th, the 9th, and the DC Circuit. This bill is patterned after that, and it wasn't struck down. None have been thus far. No state bill and the last federal bill. So I just wanted to say that. I want to thank everybody. Senator, I want to apologize to you. You sort of got my dander up, and that happens on occasion, but...
First time ever.
Mr. Chairman.
Thank you.
Mr. Chairman, may I ask a unanimous consent?
Certainly.
That my vote be recorded as present and not by proxy. It will.
I was going to suggest that, and we're glad that I know you've been going through a rough About time you're back. We're glad to have you back, and your votes will be recorded as in person, so we can go back and forth.
He was medevaced
Senator Graham, then Senator Schumer, and before we leave, I will have a statement too. But I'll yield to everybody first. Senator Graham.
Thank you, Mr. Chairman. I'd like to make the same request of Senator Whitehouse. I think I missed a vote, but I'd like to be recorded as present. To Senator Feinstein, you have been consistent. You're as sincere as the day is long, and I completely understand your point of view. And I will vote no because for a couple of reasons. Number one, about the capacity of the clip. One bullet in the hands of a mentally disturbed person or a felon, a gang member, is one too many. There are thousands of these high-capacity clips in circulation today. But I could see a situation where an individual citizen would need more than 6 bullets or 10. Most assaults, not most, a third of the assaults that occur are by more than one perpetrator. And I keep going back to the situation of the lady in Atlanta a couple of months ago. A man broke into her home. She was at home with her twin daughters. He'd just gotten out of jail, had a crowbar. She ran up to the second floor of the house and hid in the closet with her children. On the phone with her husband, she had a .38 revolver, 6-shot revolver. The guy broke into the closet. She emptied the gun, hit him 5 or 6 times. He was still able to get up and drove away. Thank God there weren't 2. In that situation, it would not bother me at all, Senator Feinstein, if she had 30 or 100 bullets. It does bother me what happened in Connecticut and other places where people go in and take innocent lives with any kind of weapon, any kind of magazine. Now, how do you interrupt the shooter? The theory is if you limit the size or the capacity when you have one of these mass shootings, it will give a break in the action so somebody can stop the shooter. That makes sense to a certain extent, but I can assure you it is a really false sense of interrupting the shooter. It has a certain logic to it, but I think we could have a better system. If you had, there's $300 million spent on securing this Capitol. You can't walk anywhere in here without some armed guard. Why? Because this is a magnet. This is the center of democracy. A lot of people would like to do harm to the building, what it stands for, and the people inside. I believe the best way to interrupt the shooter is to have a mental health system that actually records and enters into the database people who should not be able to buy a gun. In South Carolina, a lady was able to purchase a gun lawfully who had been pled not guilty by reason of insanity in federal court to killing the President of the United States. The system did not capture her. There are so many better ways to deal with this. As to the assault ban, 2.4% of the murders last year were caused, the instrument was a rifle, not an AR-15, but a rifle. So we're really focusing on what I think is an emotional part of the problem, but will create a false sense of safety. And I've said this probably more than I should. I own an AR-15 not out of animosity or paranoia that life is going to, disintegrate in my community, and I would need it. But there are circumstances where if you did have a situation where lawlessness took over from a national disaster, that self-defense component of an AR-15 is, to me, far greater than a double-barrel shotgun. But you don't have to agree with me. The reason I bought the AR-15, I served in Afghanistan as a reservist, and people in my unit were buying AR-15s and M9s with the logo of the unit. I haven't even shot it yet. I need to go out and shoot it. But that's why I bought it. That's why the people in the unit bought it. And I would just suggest that this legislation has been tried before. It really didn't appreciably change things. And after the Heller case, I really do believe that there's a very good argument the law now is unconstitutional because traditional lawful purposes such as self-defense. I can make a logical argument where an AR-15 is a better weapon in certain circumstances than other weapons that one may want to buy. Common use at the time, there are over 4 million of these guns. It's not like I'm the only one in America with this. There are 4 million. It's the #1 selling rifle, I think, last year. Not dangerous, of course it is, and unusual is the second, is the third test. It can't be unusual in the circumstances of what's going on in America in terms of people purchasing the rifle. And having said that, I will vote no, but it's not about questioning Senator Feinstein's motives. We just see things differently. She has been doing this for a very long time because she believes it will help. And I believe it will not appreciably change things and is giving a false sense of safety, and there are better things we can do in a bipartisan way to address gun violence. The crooks are going to get the guns. And if you ever find yourself having to meet one of these crooks, I want to make sure you can defend yourself. Thank you.
Mr. Chairman.
I would note for everybody, and I'm certainly going to stay here, as I said, I'll stay here as long as anybody wishes to speak. I would just note, out of consideration for everybody, there is going to be a vote in a few minutes, at which point we will have to recess and come back. But Senator Schumer, you've been patiently waiting.
Yeah, I wasn't going to speak, but I do want to make a point. It's in reference to the dialogue between the senator from Texas and the senator from California. You know, even before Heller, I'd go to upstate New York to gun clubs, and people would say to me, why is it that people down in New York City want to interpret the First or the Fourth Amendment broadly and expansively and see the Second Amendment through the pinhole of militias, and only if you were a member of the reserves or National Guard would you have a right to bear arms? And as I thought about it, they had a point. Heller made that point in a constitutional sense. It said that there is a right to bear arms, and a non-militia member, a non-reservist in Washington, D.C., had that right. And I think that's a good thing that they said that. And I've made speeches and arguments that those of us on the more progressive side should accept that argument. But Heller made a second point, and that is that there are limits on the Second Amendment the way there are limits on every other amendment. And in fact, specifically in regard to my good friend from South Carolina, under Heller, the D.C. Circuit explicitly upheld the D.C. assault weapons ban as a reasonable limitation. But my point goes more large than that. We now have the inverse situation. Our folks, some folks, defend the Second Amendment to all limits. There are no reasonable limitations on the Second Amendment, and many of those very same people would much more narrowly interpret the First Amendment or the Fourth Amendment or some of the others. So in reference to the question my colleague from Texas asked, would you limit books? Would you name specific books? Yeah, it's constitutional within the ambit of the First Amendment to eliminate child pornography. And we have lots of laws that are very explicit about that. Very explicit, that are constitutional, have been upheld as constitutional. Similarly, you can't falsely scream fire in a crowded theater. Similarly, we have libel laws. Every one of these is an impingement on the sacred First Amendment, upheld as constitutional. There are reasonable limits on each amendment. And I think it is anomalous, to put it kindly, for either side to say, to interpret one amendment so expansively and another amendment so narrowly that it just doesn't add up, because your interpretation of the Constitution should be consistent. And this is particularly true now, I would say, to my friends who defend the Second Amendment. To too many people, there are no limits, none.
That's true.
No reasonable limits. And it makes no sense. You can still believe in the right to bear arms, which I believe in, and say, for instance, that there are certain arms that may not fall in that ambit, certainly in certain instances. Certainly, it would seem to me that making sure that there's a background check under the Brady law and making it more, making the background check more effective is constitutional, although some on the other side have said it's not. So I wish we could all come a little bit more to the middle on this issue. I wish that those of us on this side of the table, and I think we do, and certainly Heller did, believe in there's a right to bear arms, and it is no less a part of the Constitution than other parts of the Constitution. But I would hope that some of my colleagues on the other side of the aisle would realize, and recognize is a better word, that there are reasonable limits on the Second Amendment, just as there are reasonable limits on all of the other amendments. Mr. Chairman, thank you.
Mr. Chairman.
Very much, Senator Durbin, you were seeking.
Well done.
I want to thank my colleagues from California and New York for their statements, and just add that there are a couple of things I would like to note. Today is March the 14th. It is 3 months since Newtown, Connecticut, on December the 14th. What happened in that classroom and the classrooms of that school at Sandy Hook was a national tragedy. Senator Feinstein, thank you for bringing this back for our consideration. The AR-15 that was used that day to kill those innocent children and 6 brave teachers and administrators is a weapon that really should be restricted in this country, not to those who currently own them, but future sales, and that's what you address. And I think it has been held up before and again in the courts that these assault weapon bans are constitutional. We held an express hearing on this, which you attended, and Dr. Lawrence Tribe from Harvard testified and said that the argument that this legislation is unconstitutional is decidedly a losing argument. Justice Scalia, no liberal, made crystal clear in the Heller decision that there is, quote, historical tradition in our country of prohibiting the carrying of dangerous and unusual weapons. Assault weapons, that end of quote, assault weapons are disproportionately dangerous when used in assault, and they represent a small fraction of the guns in circulation. There is no doubt in my mind that your law, as has been held by previous courts, is constitutional, and there is sound standing for it to be considered. And this notion that, well, it's such a small percentage, it may be a small percentage, but the tragedies we have witnessed in the use of these assault weapons are reminders that we cannot stand idly by, and as Senator from New York has suggested, argue some absolute position that will not allow us to make schools and neighborhoods and homes safer in America. Thank you, Mr. Chairman.
Good job. Senator Cruz.
Thank you, Mr. Chairman. I think all of us understand the passions that this topic elicits. But in my view, decisions in this body on everything, and especially this topic, should be driven by facts and the data and by the Constitution, not by passion. So I'd like to make 4 points briefly. Number one, machine guns are already functionally illegal. When this topic is discussed in the public forum, a great many people, when they hear the phrase assault weapon, believe that what is being discussed is fully automatic machine guns. Senior Senator from California made reference to an AK-47, I believe wielded by a gang member. An AK-47 is a fully automatic machine gun that is functionally illegal today. Tragically, gang members don't tend to follow gun laws. Number two, this bill, the data demonstrate, would be singularly ineffective in preventing violent crime. That, I think, is not surprising because, as the hearings on this bill demonstrated, the weapons that would be prohibited by this bill are functionally identical to semi-automatic deer rifles, millions of which are in circulation. And this bill targets cosmetic features on guns, cosmetic features that at the end of the day make the guns appear scary, but does not alter the basic mechanism. And I would note that we don't have to hypothesize about the effectiveness because we in fact have seen what happens when a very, very similar bill is in effect. The prior assault weapons ban was in effect for a decade. 3 times the Department of Justice funded studies on that assault weapons bill, and 3 times the studies were not able to find any statistically significant impact on violent crime as a result of the assault weapons ban. That's 3 studies in a row, which is very difficult to get away from. And indeed, since the assault weapons ban expired, we now see murders by rifles are roughly half today what they were when the assault weapons ban is in effect. So this is not a law that I think has any reasonable prospect of reducing violent crime, something I know everyone on this committee would like to see violent crime reduced. Indeed, I would suggest, as my third point, that if the real objective is reducing violent crime, we should be devoting our time to far more effective steps. We should be devoting our time to laws that target violent criminals. We should be devoting our time to laws that improve the NICS background check. We heard testimony that 18 states right now have submitted 100 or fewer mental health records to the background check program. That's a serious problem. I would note my home state of Texas has submitted over 200,000 mental health records to that background system. And I fully expect to support on the floor legislation that is targeted at violent criminals and not at law-abiding citizens. Indeed, if we wanted to go further and really consider significant steps to stop violent crime, I would suggest we could consider legislation or a constitutional amendment to alter or repeal the exclusionary rule in criminal proceedings. Now, there is a rule that consistently excludes evidence of guilt from violent criminals and has resulted in violent criminals being freed over and over and over again. If the passion that is focused on this issue right now were targeted at preventing violent crime, I would suggest considering the impact of the exclusionary rule would be a far more fruitful area for actually stopping violent crime. Because I too, as many of the members of this committee, have worked in law enforcement for many, many years, have dealt with victims of crime, and think we need to be serious about protecting Americans from violent crime with every tool at our disposal. My fourth and final point is that the Constitution, in my opinion, should be the touchstone of everything we do. Some have suggested in this hearing that the role of Congress is to pass laws and it's up to the court to consider constitutionality. I would point out that every one of us takes an oath to defend the Constitution.
Thank you for the lecture.
And that is a fundamental obligation of every member of this body. There has been some suggestion that Heller would allow this regulation. I would point out that I am not unfamiliar with the Heller case. Indeed, I represented 31 states before the U.S. Supreme Court in the Heller case. So I have an intimate familiarity with that case, having been an active part of litigating it and winning 5-4 before the Supreme Court. And what the Supreme Court said in Heller, it did say there are some restrictions on the Second Amendment that are permissible. And for example, it specifically identified the current prohibition on fully automatic machine guns. But it also said that weapons that are in common use, such as, in that case, handguns, were the principal issue being discussed. And the same arguments that have been suggested here about why so-called assault weapons can be banned were made by the District of Columbia and Heller for why handguns could be banned. And the Supreme Court said, no, if they're in common use for self-defense, they cannot be banned consistent with the Second Amendment. We have heard testimony that there are some 4 million weapons that would be covered by this bill. I would suggest on any measure, 4 million weapons qualifies as in common use, and so under the terms of Heller, they cannot constitutionally be prohibited. The final point I would make on the Constitution is some have pointed to public opinion polls. In my view, the Constitution is particularly important when the Bill of Rights is unpopular. That was the entire purpose of the Bill of Rights. When our rights are popular, we don't need the Constitution. The purpose of it is to stand for the rights of the minority when the majority is acting to strip their rights. And I would note the senior senator from New York asked about other rights. I think we should be vigorous in protecting every right in the Constitution. Just last week, a number of us spent some 13 hours on the floor of the Senate defending the Fifth Amendment, and in particular, the right of Americans not to be denied their life without due process of law. And indeed, Senator Rand Paul and I have introduced legislation to make clear that the United States government cannot use a drone to kill a U.S. citizen on U.S. soil if that individual does not pose an imminent threat. And I would certainly welcome support from any of my colleagues on the other side of the aisle on that important protection of the Fifth Amendment. Just this week.
I don't want to and will not cut the senator off. He's made the 5 of his 4 points.
Mr. Chairman, I would...
But we are going to have a vote in a few minutes, and I would ask him to, and I'll say if he wants to make a longer one, and I appreciate the lecture of what we're supposed to do as senators opposing the Constitution. I've been doing it for 38 years, but I'm always happy to have the reminder from somebody who's been here for
Mr. Chairman.
Probably not quite as long, but I'd like to let some of the others,
but
if you don't mind.
I asked the gentleman
Mr. Chairman, if I could have the 60 more seconds to conclude.
Go ahead.
Okay, I'll do it later. Yeah, okay. He's got 60 seconds.
Likewise, earlier this week, this committee voted to fund a study of the impact of films and video games on violent crimes. And I would note that I voted no against that as well, because I believe in the First Amendment, I believe in the Second Amendment, I believe in the Fifth Amendment, and I would suggest that every one of us has an obligation to the Constitution. I will happily welcome support from anyone who wants to stand and fight for the Constitution, because in my view, that should be our principal responsibility and obligation. Thank you, Mr. Chairman.
I thank the Senator. Senator Whitehouse.
Okay. I'll speak briefly. It's pretty clear where...
Is your microphone on?
My microphone, I believe, is on. I think it's pretty clear where this is going and where the political forces have arrayed themselves. I understand. And I would hope that as we go to the floor, I can work with Senator Feinstein and others to make sure that we get a separate vote on the high-capacity magazines question. It's pretty clear that the assault weapons ban has become, the other parties become locked in against that, and so I don't see us getting 60 votes. I do think it's possible to get 60 votes on the high-capacity weapons ban. It is hard to imagine that it can be a violation of the First Amendment for somebody to yell fire in a crowded theater, but it's not a violation of the Second Amendment to prevent somebody from bringing a 100-round magazine into a crowded theater in Aurora, Colorado. We have heard testimony in this committee, very specific testimony, about lives that would have been saved if there had not been those high-capacity magazines. We heard from Representative Gifford's husband about the shooting in which he mentioned the child who was the 13th shot victim would not have happened if he'd had to reload sooner. We heard from the U.S. Attorney prosecuting the Aurora case about the harm that was the direct consequence of having the capacity of magazine that individual had before the weapon jammed. We heard from the police chiefs. There has been no testimony to the contrary. Indeed, the Republican witnesses have specifically said that these high-capacity magazines, at least at some level, are outside of the Heller decision. That was an admission by one of the pro-gun Republican witnesses. So I think there is room to maneuver there. There is logic behind it. There is unrebutted testimony behind it. It does not interfere with the prescriptions of Heller, and I hope that we can at least agree to get that passed. We can't unless we get a vote on it, so I hope we can work together to make sure we get, in addition to a vote on the assault weapons ban on the floor, a vote on the high-capacity magazines restriction.
Well, I appreciate that. I'd note to the Senator, there's been a lot of talk about what Congress can do. So far, this is the only committee that's held hearings on gun violence in either body, and the only one that has actually taken up and passed out legislation, and we've done it in 2 months' time. Senator Franken.
Thank you, Mr. Chairman. I'd like to congratulate Senator Feinstein on today's vote. It's an important step. I know that she worked tirelessly on this legislation. We've been debating this legislation for about 3 months. There are strongly held views on both sides. That's not just okay, it's good, obviously. I respect the perspectives and opinions of every member. Minnesota has rural areas. The Minnesotans feel different ways about this. But as the bill now moves to the full Senate, some of the bill's co-sponsors, I guess it's me and Dick remaining, Dick Durbin talked about constitutionality. But we'd like to talk to some of the arguments that have been made against the bill.
One of the arguments that we've heard repeatedly is that independent Justice Department studies proved that the last assault weapons ban was ineffective, and I kind of wish that the junior senator from Texas was still here. During our first hearing, one witness stated, quote, independent studies, including a study from the Clinton Justice Department, proved that the assault weapons ban had no impact on lowering crime, unquote. During our last committee hearing, it was the junior senator who said, talking about that study, that was the Janet Reno Department of Justice under President Clinton that said the assault weapons ban was singularly ineffective. During last week's executive meeting, one of my colleagues said, quote, according to the Department of Justice's own study, the ban was completely ineffectual in reducing murder or violent crime rates, end quote. These are simply not accurate portrayals of the studies. At the very least, the studies were inconclusive. Here's what they actually say. And as long as we have the staff here, I'd like you to hear that for your bosses. Pages 6 and 7 of the 1997 study. We recommend further study of the impact measures examined in this investigation. The ban effects on the gun market are still unfolding. Page 2 of the 2004 study. It is premature to make definitive assessments of the ban's impact on gun crime. Page 80 of the 2004 study. It is premature to make definitive assessments of the ban's impact on gun violence. Page 96 of the 2004 studies. The law's effects are still unfolding and may not be fully felt for several years into the future. Page 98 of the 2004 report. The effects of the assault weapon ban and large capacity magazine ban have yet to be fully realized. Therefore, we recommend continued study of trends in the availability and criminal use of assault weapons and large capacity magazines. I could go on, but the bottom line is that I don't see how anyone could read the DOJ studies and say that they proved that the last ban was ineffective, and yet that is what two members have asserted, have stated, and I respect their opinions. They have a right to their opinions, as Pat Moynihan once said. They don't have the right to their facts. If anything, the report suggests an assault weapons ban would be effective over time. The 1997 study said that the author's best estimate was that the ban contributed to a 6.7% decrease in total gun murders, though the authors noted that the data were insufficient for them to make a scientific conclusion. The 2004 study included an analysis of ATF gun tracing data, which suggested the use of assault weapons in crimes fell by more than 2/3 after the last ban went into effect. And courtesy to my colleague from Connecticut, I would like to ask him to speak to a couple of the other arguments that have been made that I think bear some rebuttal.
Senator Blumenthal, you've been recognized by Chairman Franken. Please go ahead.
Thank you.
I apologize.
Thank you.
No apology needed. I'm delighted to have
Well,
you
I
speak.
sense a hint of sarcasm, sir.
I'm sorry. I thought you were just doing an understatement. But go ahead.
Well, understatement can be sarcasm. We'll talk about this later.
I am very hesitant to follow that exchange, but
Don't.
thank you, Chairman Leahy. And I want to thank my colleague.
And I also want to, in all seriousness, I want to thank Senator Franken for what he brought up. And it was a point that should be emphasized over and over again. We all have opinions, but we have to deal with facts. And Senator Franken was dealing with facts, and I appreciate that. Senator Blumenthal.
Thank you, Chairman Leahy. And I want to thank Senator Franken for his very thoughtful and well-informed factual rebuttal of some of the points that have been raised here, and also to Senator Feinstein for her unremitting and relentless pursuit of this measure, which consists of both a ban on assault weapons, which are defined very explicitly and carefully in this bill, and high-capacity magazines. Both were integral to the massacre that occurred just 3 months ago in Newtown, Connecticut. For me, as for her, this issue is very personal. I was there within hours of the mass killing, and I saw the grief and pain that resulted from a murder on a scale that could not have occurred without assault weapons and high-capacity magazines. Lives were saved because the shooter had to change magazines. Children escaped because he could not shoot more than the 30 rounds in the clip that he began with. But he did change clips, and he continued shooting with a weapon that was designed to be among the most lethal in the arsenal that military men and women carry with them in combat. It was a weapon designed for combat, to be as lethal as possible. And that's essentially what defines the assault weapon that is banned in this legislation. It has a definition of characteristics such as a pistol grip, barrel shroud, forward grip, threaded barrel, detachable magazine outside of the pistol grip. These characteristics that are in the legislation are not there by accident. They are there because they make this weapon more lethal and more dangerous. The argument for self-defense in the Constitution has been approved by Heller. We can't deny it. But constitutionally, that does not mean that machine guns are constitutionally protected, or bazookas, or any of the other kinds of weapons that the military carries to kill enemy combatants. And we've had a lot of testimony about these military characteristics from law enforcement. Chief Flynn, for example, who described the specific characteristics that make these weapons more lethal, from John Walsh, the U.S. Attorney, who testified before our committee, and from Mayor Nutter, who said about them, they are offensive weapons. That's what you use them for, because you're on offense. So there are specific definitions in the bill that I think comport with the Due Process Clause as to the specificity of definition. I've defended the Connecticut assault weapon ban in our state courts, and it was upheld against all of these challenges. And I would just point out that the exemption for retired police officers is based not only on their training, but also on the role that they can play in continued law enforcement. Just as off-duty police officers do, retired police can often play a role in deterring or pursuing criminals. But the basic point here is that children and educators would be alive today but for the assault weapon and the high-capacity magazine that was used in that horrific criminal act of 3 months ago. Our law enforcement officers would not be outgunned if this ban were in effect. This is a law enforcement tool. It is supported by law enforcement officers and professionals. The other measures that have been suggested here, mental health, for example, has a role to play, and so do some of the other initiatives that we've sponsored and supported and passed from this committee. There's no single solution. No single state can do it alone. We need this protection, and I am appreciative that our chairman has permitted it to go to the floor, where I believe there may well be an effort to divide the assault weapon ban from the high-capacity magazine ban. I welcome that kind of split, but not because I want to vote for one or the other. I will vote for both because I think both help us prevent Newtown, which was a call to action, and we are heeding it today. Thank you, Mr. Chairman.
Thank you. I thank the senator from Connecticut, and of course, he and I have known each other for years, both in his capacity as Attorney General and more recently as a member of the Senate. I appreciate what all of you brought to it. It's been a serious subject. I appreciate it. I said Senator Franken said about the facts, and of course he's right, and it's something that should be driven home over and over again. Senator Feinstein, who has devoted time on this from, I think, from the first time we met, and I appreciate her devotion to it. It is not a abstract pie in the sky. I think anybody who reads the history of what she faced and how she became mayor of San Francisco would understand. Now, Senator Blumenthal, I remember the emotion in your voice when I talked to you. You were about to go to meet the families of the victims that I'd called you in the conversation we had. I said that we would do what we could about gun violence, and we devoted our first hearing of this Congress back in January what to do about gun violence. The first hearing of either body for years. And I've asked this committee, I've asked all senators, Republicans and Democrats, to come together as Americans, not as partisans, as part of a collective effort to find solutions to help ensure that no families, no community be made to endure the tragedies of the past few years, whether in an elementary school in Connecticut, a movie theater in Colorado, in a sacred place of worship in Wisconsin, in front of a shopping mall in Arizona. Now, Americans are looking to us for solutions and for action. After 3 hearings, 4 markup sessions, we've essentially completed our work. We sent measures on to the Senate for consideration. I'll now work with the majority leader, see how he intends to proceed. We have worked to try to provide law enforcement with stronger tools against illegal gun trafficking. And to close that loophole, we've proposed enhancements to school security. We propose closing loopholes in our background check system for firearm purchases. Others have proposed restrictions of military-style weapons and the size of ammunition clips. Now, I know gun store owners in Vermont. They follow the law. They conduct background checks to keep guns out of the hands of those who should not have them. They wonder why others who sell guns do not have to follow these same protective rules. And I agree with these responsible business owners. If we can all agree that criminals, those adjudicated as mentally ill, should not be buying firearms, why shouldn't we plug the loopholes in the law that allow them to buy guns without any background checks? Why shouldn't they all be subjected to the same checks that I am when I buy a firearm, or anybody else in this room? Why shouldn't the law apply to everybody the same? It's common sense. Previous measures to close the gun show loophole or to improve the background check system have been bipartisan, and I hope we can make further improvements in a bipartisan way. I noted at the outset the Second Amendment is secure and will remain secure and protected. I yield to no member on this committee my devotion to protecting our Constitution, every part of our Constitution. In 2 recent cases, The Supreme Court has confirmed that the Second Amendment, like other aspects of our Bill of Rights, protects a fundamental individual right. Americans have the right to self-defense and to have guns in their homes to protect their families. No one can, nobody is going to take those rights away or our guns away. Second Amendment rights are the foundation on which our discussion rests. They're not at risk. Let's not put an issue out here that is not out here. But lives are at risk when responsible people fail to stand up for laws that will keep guns out of the hands of those who would commit mass murder. Ours is a free society. It's an open society. Let's come together to become a safer and more secure society. We need consensus around common sense solutions. What we do not need are false charges about gun registries and gun confiscation to scare people when no such thing is being proposed or will be proposed. These matters are too serious for that. So as we began our efforts, I challenge other senators to come forward, to work together, to indicate what measures they would support. And I thank the ranking member for making that effort. I'll continue to work with him and others to see if we cannot find more things on which we can agree and more solutions on which we can move forward together to make Americans safer. On a personal note, I appreciate so much the honor of being chair of this committee. It is a committee I wanted to be on from the day I came to the United States Senate. I've had the privilege to become the longest serving member of this body. I have seen times when Republicans and Democrats come together on very serious issues. For the sake of our country, of our children, of our grandchildren, let us come together and find some sensible steps that can make us safer as a nation. We are too great, too wonderful a country to do otherwise.
Well done, Patrick. Well done.
Yeah.